who is a shareholder in the Chicago office of McAndrews, held in Malloy. He has a MS in mechanical engineering as well as an MBA from Rensselaer Polytechnic Institute. He graduated from this fine law school with highest honors, where he was an executive notes and comments editor for the Chicago-Kent Law Review. And then he went on to clerk for the Honorable John A. Nordberg of the Northern District of Illinois. Bob?
Thank you, Ed. Thank you. Well, welcome. I've got two fine panelists with me here. First is Professor Mark Lemley. He's the William H. Newcomb Professor of Law at Stanford Law School, director of the Stanford Program in Law, Science, and Technology, and the director of Stanford's LLM Program in Law, Science, and Technology. He teaches intellectual property, computer and internet law, patent law, and antitrust, and is the author of 7 books, over 130 articles, and various amicus briefs. Professor Lemley has published 9 of the 100 most cited law review articles over the last 20 years, and in a 2012 empirical study, he was named the most relevant law professor in the country. Relevant to this case, the FTC versus Actavis case, he filed a Friends of the Court brief on behalf of 118 law and economics and business professors and on behalf of the American Antitrust Institute. Our other panelist, Bob Breisblatt, is a partner with Catton, Muchin, Rosenman in Chicago and is the national co-head of the firm's intellectual property practice and co-head of the patent litigation practice. He's an experienced trial and appellate attorney and has tried numerous intellectual property matters and argued many appeals before the federal circuit. Early in his career, he was an assistant U.S. attorney and a lieutenant in the United States Army. And on a personal note, when I was a law clerk to Judge Nordberg, Bob appeared before us in probably one of the first Markman hearings in the United States at that time. And it was probably one of the longest Markman hearings at the time. And I remember it dealt with dental implants, and whenever we would take breaks, I would go and floss my teeth. Because it was just, welcome, and I know these gentlemen are anxious to talk to you. So let me just give a brief summary of the case and we'll get right to it. In FTC versus Actavis, it was a suit brought by the Federal Trade Commission against parties to a reverse payment settlement. The Supreme Court held that governments and private entities may bring lawsuits against brand name pharmaceutical manufacturers to challenge so-called reverse payment settlements. In those settlements, the brand pharmaceutical companies make to generic drug competitors to keep the generic version of the brand drugs out of the market until the patent expires. The payments are reversed in the sense that the potential infringer is paid not to challenge the validity of the patent owned by the brand name pharmaceutical company. The court further held in that case, however, that reverse payment settlements are not presumptively illegal, but should instead be examined under the rule of reason from antitrust law. So I think the first question to the panelists here is, who won here? Is it generic drug manufacturers, consumers, the Federal Trade Commission, none of the above? And Mark, why don't you start and turn it over to Bob after that?
Sure. I mean, I think the answer depends a little bit on what happens next. The win is clearly a win at one level for the Federal Trade Commission. The appellate courts had split on how to deal with these reverse payments before this case, but the trend seemed to be towards treating them as per se legal. That is to say, throwing out antitrust challenges on a motion to dismiss. And that trend, I think, has now been stopped in its tracks. The court says these agreements look facially anti-competitive to us. You're paying someone to avoid the possibility that your patent will be invalidated, and that's an antitrust problem unless there's something else going on that can explain it. Now, the Federal Trade Commission didn't get everything it wanted. The commission had asked, and my amicus brief had argued, for a rule of presumptive illegality for these payments that would kind of switch the presumption and say, unless there's some particular extenuating circumstance, we can presume these are illegal. The court, in one sense, kind of took a halfway position. It said, well, these things are clearly not legal per se, but you've got to apply the normal antitrust doctrine of the rule of reason. Now, the normal antitrust doctrine of the rule of reason in general involves a lot of economic evidence, market definition, market power analysis, and a balancing of the costs and benefits of each of the pro and anti-competitive merits of the position. I don't think that that's actually what the court had in mind here, and I think we can talk about that. The rule of reason the court seems to envision looks a lot like presumptive illegality. The things that the court talks about as permitting a reverse payment are pretty limited. So here's what the court says, for instance, and actually repeats this twice at two separate points in the opinion. Why might a reverse payment not be illegal? The reverse payment, for example, may amount to no more than a rough approximation of the litigation expenses saved through the settlement. That payment may reflect compensation for other services the generic has promised to perform, such as distributing the patented item or helping to develop a market for that item. And there may be other justifications, though the court never specifies what they might be. But they come back to kind of only two pretty narrow, plausible justifications. This is a small payment that's no more than the cost of settlement, or this is actually a payment not in exchange for settlement, but for some other business deal or transaction between the two parties. If those things aren't present, as I read the court's opinion, most of these agreements are going to be illegal. If that's right, I think it turns out in the long run to be a pretty big win, both for the Federal Trade Commission and for consumers who get lower prices across the range of these agreements.
Bob, before you comment, I just want to also note that Bob filed an amicus brief on behalf of Apotex in this case, and just wanted to note that. So go ahead, Bob.
Actually, the big winners here is the plaintiff's antitrust bar. And I say that because the plaintiff's antitrust bar traditionally has looked at these settlements and where they can and where they were in circuits that would allow it, they challenged the settlements. And the plaintiff's antitrust bar represents a large collection of all sorts of payer-payee groups. So in some cases, they represent the Walgreens and the CVSs. In other cases, they represent pension plans. This will allow them now to challenge these kinds of settlements in all the circuits throughout the country, as opposed to trying to seek out the Third Circuit, which before the Supreme Court case decision had one of the most helpful cases for the plaintiff's bar, and that was the Cater decision, where they, I think, went almost to the full extent that both the FTC would have wanted to go to in front of the Supreme Court, that it's almost per se an antitrust violation to have the reverse payment. At the end of the day, will consumers benefit? It will ultimately depend on what the outcome of the underlying patent infringement cases are. The good news and the bad news about reverse payment or settlement of Hatch-Waxman cases is, generally speaking, there will also be an earlier entry day. In the Actavis case, I think it was 36 months before the patent expiration. There is now a known date that, in theory, generics will come to market. Now, there's a lot of other things brands do to derail that, but it's hard to say. But the definite winner here is the plaintiff's antitrust bar.
So following along those lines, is the court's decision a green light to antitrust claims against reverse payment settlements, or perhaps just a yellow light?
Well, so it's a green light in the following sense that Bob says, right? It used to be the case that private plaintiffs in most circuits were going to get thrown out of court. I think that's not going to be true anymore, right? It also used to be the case that because you could appeal a Federal Trade Commission decision to any regional circuit of your choice, that the Federal Trade Commission was going to be routed into courts that were particularly unfavorable to its positions. That's not going to be true anymore, or at least the law has evened out. So in terms of bringing the cases, I think it's right to say it's a green light. What remains to be seen is how seriously the court takes the rule of reason terminology versus the actual language of the court's opinion, in which they seem to say things like, we can presume market power here, we can presume that there's anti-competitive effect, the size of the anti-competitive effect doesn't depend on validity, and you don't have to inquire into validity. If the trial courts are requiring all of those things as part of a full-blown antitrust analysis, then it may be easy to file an antitrust case, but it's going to be a very long road to win it. But if not, if what they do is focus a little more closely on what the court actually says in Actavis, that you know what, if there's a large payment, it probably means the patent was likely invalid, that the parties thought it was invalid or they wouldn't have made that payment, that there is market power and you can presume it, then the number of issues that a court would have to resolve for an antitrust plaintiff to win suddenly becomes a lot narrower, and the cases become a lot more attractive to bring. And that, in turn, I think, changes the pattern of settlement we're likely to see. And maybe we'll move to talk about that in a moment.
Yeah, I think in a lot of cases it's going to mean that you're going to have these suits brought, where I think the Supreme Court kind of leaves the jurisprudence up to the district courts to now decide what are they going to look at, how are they going to look at it, how expensive will discovery be when you start trying to probe behind the other parts of the agreement. In other words, was there something of value that was actually traded by the generic back to the brand as opposed to just the generic receiving the cash payment? The other interesting question is going to be, what is something of value? Does it have to be a cash payment? There's presently a case going on in New Jersey where the Federal Trade Commission has sought to file an amicus brief. I think it's the In re Exafor cases, because there's a question there of where what the brand promised was they wouldn't launch an authorized generic. And so everyone understands, and Roberts gets it a little wrong in his dissent, the first generic, which gets us 180 days, or the multiple generics that get the 180 days, they are not the only generic that could wind up in the marketplace. What brands have been doing in the last bunch of years is they will consider launching what's referred to as an authorized generic. And an authorized generic is simply a generic version of the brand product, either put out by the brand or put out by a licensor. Without filing an ANDA, it comes under the brand's new drug application. And it's been held that that's fine, they don't have to wait, they can launch at any time, and they don't need additional FDA approval. And so in this case in New Jersey, the brand said, we won't launch an authorized generic. So no cash payment, but simply a promise not to launch an authorized generic. To a generic entering the marketplace, particularly someone who has 180 days of exclusivity, that has a lot of value. That basically means that instead of, by the end of their 6 months, having 90% of the market, they might only have 45% of the market. So I think that's going to be one of those issues that are going to continue to have to develop in the district court jurisprudence, again, whether you get a green light. Because the concept of these large reverse payments, I don't think we're going to see any longer. I don't know if there's been a lot of those in the last, let's say, 2 or 3 years, because everybody's been concerned about the antitrust implications in terms of settlements. So they've been working other things into the agreements to see if they'll pass scrutiny of the FTC and DOJ. And the court comments on it here briefly, but just so you all know, if you settle an abbreviated New Drug Act case, you're required within 10 days of the finalization of the settlement to submit it for review, not approval, to the FTC and DOJ.
So I think that authorized generic issue is very interesting. It's absolutely right to say, particularly after this opinion, large reverse settlement payments, I think, are just they're waving a red flag in front of a bull. You wouldn't do it if you could avoid it. So then the question is, what happens next? Right? Now, one thing that might happen next, I think would be a substantial benefit to the world at large, which is patentees and generics could settle without the large cash payment, and they could settle for an earlier entry date. Right? If you're paying the generic as part of the settlement, you're almost certainly paying them to delay that entry date. So instead of saying in Actavis, we'll give you $30 million a year and you'll enter 3 months before the patent 3 years before the patent expires, maybe the pharmaceutical company would say, we'll let you enter 6 years before the patent expires. And if there's no such payment, the difference is consumers and the generic share the benefit of those extra 3 years. The generic is not getting paid, but the consumer gets the generic drug earlier. Now, the other thing that could happen, and I think Robert alludes to this, is the parties could try to disguise their payments and hope the antitrust authorities don't notice, right? And the more complicated the transaction gets, the harder it is to know whether or not the transaction really reflects not a bona fide deal, but a hidden payment. In the Actavis case itself, the parties said, well, this is a payment that's not just for settlement and for delay. The generic is actually providing valuable services to the pharmaceutical company. Now, the valuable services the generic was providing there were the generic promised to help the pharmaceutical manufacturer market its own product. That's a pretty thin smokescreen. I think most people looked at that and said that's not really likely what the payment is for, because you don't see those kind of transactions in the rest of the world. But as we get to more complex transactions, like the authorized generics issues, things get a lot more complicated. It is definitely something of value to give a generic to say, I will not launch an authorized generic in competition with you. So maybe I'm paying, if I enter into that transaction, I give them that rather than money. The generic might in turn take a later entry date. Although it's an interesting question whether offering that is itself an antitrust violation. Right? If the answer is, I go to the party and say, I'll tell you what, if you stay out of the market for a while, I promise not to compete with you at the generic stage when you do enter the market. That's something of value you're offering them, but it might also be that you're offering something of value that you are forbidden from offering because it is itself an antitrust violation. So I think it's going to be interesting to see how those cases play out.
So you've both touched on this. You know, the court's opinion doesn't offer much guidance on how courts should apply the rule of reason. So should we expect that application to differ from regular antitrust cases?
So as I indicated, I think the answer is yes. Let me just give you a couple of indications of where the court says that. So the court says, do the rule of reason, not per se illegality. Then it goes on and says, to say this is not to require the courts to insist, contrary to what we've said, that the commission need litigate the patent's validity, empirically demonstrate the virtues or vices of the patent system, present every possible supporting fact, or refute every possible pro-defense theory. And they go on to say, well, rule of reason, you know, can kind of depend on the circumstances, how much work it requires. Well, what is it they're going to require? The court comes back to language very similar to the one I read you earlier. It says the likelihood of a reverse payment bringing about anti-competitive effects depends upon its size, its scale in relation to the payer's anticipated future litigation costs, its independence from other services for which it might represent payment, and the lack of any other convincing justification. And I view this as the kind of 2 1/4 exceptions rule. If you can justify your payment if you can show that it's no more than litigation costs, and that's going to be a fairly small payment. You can justify your payment if you can show that it's really a payment for something other than delayed entry. That gets back to the question of authorized generics we talked about earlier. And then there's the kind of catch-all phrase. The Gunn versus Minton panel talked about the court not being willing to go so far as to say, absolutely never federal circuit jurisdiction. Maybe there's some circumstance, but we don't really have anything in mind. I think that's what they're doing here too. Maybe you can come up with some other convincing justification that we haven't heard yet, even though we got amicus briefs from everybody involved. We're not persuaded that there is one. We don't think there's any actual content to that, but we've left ourselves a safe harbor and out. So I think we'll see in the next year or so kind of how courts handle this. If they go the regular rule of reason inquiry, then this is a really mixed bag for antitrust plaintiffs. But if they say something like what the court is saying here, that there are these justifications, but there really aren't anymore, then it really is going to be very different than a traditional rule of reason case. In the Cephalon case that's back in the Third Circuit on remand, it was vacated after this case, the Federal Trade Commission just put in a brief arguing for a motion in limine to prevent the patentees from referring to the validity of the patent. So not just to not make it a defense, they actually affirmatively want at the trial nobody to be able to mention the possible validity of the patent at all. So we'll get some first glimmer there of kind of how circumscribed the antitrust analysis is going to be on remand.
Is that modafinil?
Is that modafinil? I thought it was Cephalon.
No, but Cephalon's the brand.
Yeah.
Okay.
Yes.
Or it's the owner of the brand. Yeah, I'm a little familiar with that. The modafinil case is interesting in that there was actually a challenge to the patent by another generic, not a first filer. It proved that the patent was obtained by fraud, and there's an unenforceability ruling. The district court had stayed the case pending to see what the Federal Circuit would do with the unenforceability ruling. They've affirmed the unenforceability ruling, but there are the main generic, they want to prevent them from, I guess, saying that. I haven't read the Federal Trade Commission's brief yet. But modafinil is an interesting case because that shows you a little bit of where the reverse payment's going to go in terms of discovery, because they're the generics who settled have tried to justify what they received. And there's all sorts of discovery and experts all saying what the value is. I think it'll make it difficult for the case to go anywhere on, let's say, a motion for summary judgment. Those become factual issues, and it becomes an expensive proposition for everybody else. So the question is, will those antitrust cases settle at some point in time? And at least probably on behalf of the generic. The other interesting thing about the Cephalon case is Cephalon has filed a motion for summary judgment against the FTC. And I expect part of it is challenging, and I haven't read that one yet either, but challenging why the FTC is still in the case. The FTC doesn't seek monetary damages. It generally only seeks injunctive relief to challenge the settlement. And in the Cephalon case, generics have now launched, and therefore there are generics in the marketplace. So it becomes interesting. The Cephalon case has so many twists and turns that it itself would make a 2-hour presentation of where everything went.
So, Mark, you touched on this in your last answer regarding the invalidity of the underlying patent. In one of the cases, they've moved in limine to preclude talking about that. Should the potential invalidity of the underlying patent be a factor to consider in these antitrust cases going forward?
Yeah, so I actually think sort of intellectually this is a really hard question. So let me give you the kind of conceptual answer and then the sort of more practical answer of where I think the court will go. In an ideal world, right, whether or not the payment for delay benefits society depends on the answer to the question, would this patent have been held valid and infringed if the parties had taken it to judgment? If the patent would have been held valid and infringed, generic would have been kept off the market for the entire period of time, and consumers are better off with the early entry. If it would have been held invalid or not infringed, the generics would have entered earlier, consumers would have benefited, we're all better off. So in an ideal world, you'd like to know the answer to the question, would the patent have been valid or infringed? The problem is, if we're going to relitigate that question in the underlying antitrust suit, we're now going to relitigate it where both of the parties who were fighting on opposite sides have an incentive to say exactly the same thing, which is, oh yeah, this was a really important patent, it was valid, it was infringed, and that's why we settled. And you have an outsider who's not familiar or not participating in the patent litigation coming in to argue the opposite. So the courts that tried to deal with the validity issue, I think, ended up kind of going with a presumption one way or the other. A bunch of the appellate courts had said, well, patents are presumed valid, so we'll just take a scope of the patent test and we'll say, you know what, PTO issued the patent, it must be valid, and so you can settle any case within the arguable scope of the patent. And the problem with that, of course, is that many patents are, in fact, invalid, and patents for which you pay a large amount of money to avoid going to trial as a patent owner might be in the category that were particularly likely to be thought invalid. And so that's what the court says in Actavis. They kind of go to the other presumption here. In challenging this 11th Circuit scope of the patent test, the court says the circuit's holding does avoid the need to litigate the patent's validity, but to do so, it throws the baby out with the bathwater, and there's no need to take that drastic step. That's because it is normally not necessary to litigate patent validity to answer the antitrust question. An unexplained large reverse payment itself would normally suggest that the patentee had serious doubts about the patent's survival, and that fact in turn suggests that the payment's objective is to maintain super competitive prices to be shared among the patentee and the challenger, rather than face what might have been a competitive market. So the court's answer to the question, and I think the answer going forward is going to be, we're not going to relitigate the underlying validity of the patent. We're going to use the size of the payment, if it's substantially above litigation costs, as a proxy for the invalidity, presumed invalidity or non-infringement of the patent. Now, the remaining interesting question, I think, is, well, what do you do in a case like Cephalon that Robert identified, where we actually later find out information one way or the other about the patent from other litigation? Should we substitute in what we later learn in other litigation for what the parties thought at the time that they settled? And that's, I think, a harder question.
Well, it is a harder question, and it's interesting because in the Actavis decision, the Supreme Court does make that very clear finding that you don't have to now litigate the patent if the payment is so large, right? That's going to be the proxy. We're not going to have to go through complex patent litigation. Now, if I'm the brand or I'm now the generic and I've got this nice settlement and I don't want to give it up, I want to litigate why this patent is now valid, right? Because I want to protect what I've gotten. I don't want to pay damages to these people. So you're going to have the situation, even though I think the Supreme Court has said, well, we're going to remove the validity and enforceability of the patent from the antitrust concerns if that payment is large enough. I don't think that's going to happen. I think the brand and the generic are going to want to pull that in, that's going to be their defense to all of this. And therefore, we should be able to put on our case showing why this was a wonderfully valid patent.
Yeah, although, right, it then begs the question of, well, why was there a large payment, right? And
Right, because there was a lot of risk. But it's going the wrong way.
Yeah, well, and I think that's really the underlying key to the debate, I think, between the majority and the dissent is, what do we do about that risk, right? I think it's right to say the pharmaceutical company is paying the generic to avoid risk that their patent will be invalidated, right? And that risk might either come from the fact that it is truly invalid and should be struck down, or it might come from the fact that a judge or a jury is going to make the wrong decision, right? More, not a jury here, I guess, a judge in almost all of these cases.
In the end of cases, yeah.
Yeah, right. But I think the Supreme Court views that risk as something you're not entitled to buy exclusion from, right? Because consumers benefit from the chance that this patent will be invalid and that people will be able to enter the marketplace. And I shouldn't be able to pay to convert what Carl Shapiro has called not a right to exclude, but a right to try to exclude into a sure thing, into 100% certainty by keeping the only possible competitor out of the market for some period of time.
Well, and I think the other important thing is the legislative framework, because under Hatch-Waxman, that was the whole theory behind the whole statute, was to allow these challenges to the patent of the brand without putting the generic at risk. And I will give you an example of a quick risk situation. In June, there was a settlement of patent litigation involving the drug Protonix. All right, the case was in the middle of the damage trial. There had been a launch at risk, and The settlements alone were over $2 billion. So when you start talking about these drug cases, particularly popular drugs, the amount of damages, if the patent is ultimately held to be valid, that the generic would face, let's say if it launched at risk, if it took the risk, are literally enough to bankrupt most generic companies. So there is a lot of incentive for the generic to settle, to get out of this case, to ultimately launch a little bit early. But on the other hand, if they don't launch at risk, but they simply try the case and they're successful, the reward is huge. So the question is, where is the generic wanting to go? And what does the brand want to do? Why does it want to take the risk to its franchise? And in open court, in Protonics, in the opening by the plaintiff's lawyer, they had a really amazing chart that showed Protonics was selling $2 billion a year. The generic entry came, and within 2 months, those sales were down to, just less than $100 million or about $100 million. I mean, it just was a remarkable chart that I'm sure the jury took a good look at and probably helped aid settlement, but it tells you the impact of a generic entry on a brand in the marketplace.
So what will be the likely effect of the court's decision on Hatch-Waxman challenges, do you think?
Well, I think the challenges will continue. I think the settlements will continue. The question will become, from let's say a generic perspective, they don't want to get now entangled in antitrust litigation. The brand definitely doesn't want to get entangled in antitrust litigation, and enough brands are under consent decrees from the FTC that they get looked at pretty strictly. But there still has to be a negotiation, and having been involved in some settlement negotiations in ANDA cases, the generic is always pushing for that earlier entry date. And the brand is always trying to hold them out as long as they can. Those will still go on. That's where the negotiation will take place. And there are risks even with the generic. The generic will seek as much protection as they can from the brand. And what do I mean by that? Even though they might now get shot down completely, we don't want you launching an authorized generic. Another type of protection that's already built into these agreements is if somebody else challenges a non-first filer, let's say, and they invalidate the patent, we get to launch right away. And there'll be provisions in there that if you do launch as a generic or there's an at-risk launch, you'll have to pay us damages, the brand will say, but it'll be more limited. They'll look at some kind of moderation. So the generic is looking for protection. But what are some of the other areas? Brands are notorious for something called evergreening, meaning they have other patents in the pipeline on that molecule, maybe a method of use, maybe a delay release. And you might have a generic who thinks they've cut this great deal. They're going to wait 6 years to come to market, thinking they'll then have their 180 days of exclusivity. And in year 5, the brand launches their next product and takes that marketplace away. And it's happened time and time again. Now, having said that, brands are having less success with that if it's not a major shift in the product. You now have certain brands have come up with the next great thing, the generic goes to market, and doctors, because the brands can't come in and offer them all sorts of inducements any longer, are still prescribing that generic product. So that's all part of the tension that goes into the settlement negotiation. Not going to stop them. There'll still be settlement negotiations. Where they're going to wind up and what gets offered will be something to be looked at.
And then there's one other effect to consider, which is I think at the margins, we might see somewhat fewer generic challenges if the generics can't get paid to sort of stop the challenges. Right? I think there's some level of generic challenges that are basically there no matter the strength of the patent, just so that I can be paid to go away. If those are happening, right, those might disappear as a result of this. That doesn't trouble me greatly, right? Those aren't the ones that were going to benefit society, right? Those were the ones, if I'm really challenging a strong patent just to see if I can get some money, it doesn't break my heart if those challenges go away.
So do you see, we've been talking about this obviously in the context of pharmaceutical litigation. What are the broader implications, if any, for cases, IP antitrust cases outside of that field?
So perhaps the most notable thing about the Actavis opinion is not actually its holding on the pharmaceutical cases, which I think really is pretty closely tied to the Hatch-Waxman regulatory context. It's the framework in which the court uses to approach this issue. So the traditional framework for the last 45 years that we've used to think about IP and antitrust is the IP right exists, and within its scope, it is supreme, and antitrust polices efforts to try to extend it, right? To extend it in time, to expand it beyond its scope, to use a licensing agreement to cover other things, and so forth. The Supreme Court in Actavis does not take that approach. It takes a very different approach in which it says, no, both antitrust and patent law have a role in deciding the proper scope of the patent monopoly. And the language here is really quite remarkable. So they reject the idea of the scope of the patent test, saying, you know what, we'll accept that the evidence suggests something's within the scope of the patent, but we don't agree that that fact can immunize the agreement from antitrust attack. It would be incongruous to determine antitrust legality by measuring the settlement's anti-competitive effects solely against patent law policy, rather than by measuring them against pro-competitive antitrust policies as well. It cites a bunch of its own cases from the 30s and 40s, saying what we're doing is seeking an accommodation between the lawful restraint on trade of the patent monopoly and the illegal restraint prohibited broadly by the Sherman Act. Court of Appeals answered the antitrust question by the Supreme Court in the past has answered the antitrust question by considering traditional antitrust factors such as likely anti-competitive effects, redeeming virtues, market power, and potentially offsetting legal considerations. Whether a particular restraint lies beyond the limits of the patent monopoly is a conclusion that flows from that analysis, and not, as the dissent suggests, its starting point. As a result, we don't ask simply whether the patent, hypothetically valid patent holders could be able to charge a high price. Rather, we seek to accommodate patent and antitrust policies, finding challenge terms and conditions unlawful unless patent law policy offsets the antitrust law policy strongly favoring competition. What that says to me is, maybe even outside the Hatch-Waxman context, we've got a different game. We're now focused not just on have I expanded the scope of my patent beyond its lawful right. We're focused on the definition of the lawful right itself being a result of the interplay between patent law and antitrust law. And if that continues, it has, I think, some really significant implications, not just for Hatch-Waxman cases, but for the full range of IP antitrust cases.
I agree, and I think the dissent was afraid of that when you read the dissent. They see this as a backing away from the scope of the patent test when looking at any kind of patent settlement.
I have a bunch of questions here, but obviously I want to turn it over to we're running out of time here, and I wanted to turn it over to the audience to see if there's any questions from the audience.
Hi, this question is Professor Lemley. These cases, this has been going on for like 10, 15 years or something like that, right? And there have been a lot of other cases that would have, I don't know, I guess, given a broader discussion to the Supreme Court's opinion. Why do you think they took this case?
Well, I think various parties have been encouraging them to take a case for some time. Very early on, these payments started in the kind of 1990s. People started challenging them in the late 1990s. The earliest decisions in the DC Circuit and the Sixth Circuit were pretty critical of them. And then we saw the pendulum start to swing towards much more favorable rulings. So the 11th Circuit said, well, it depends on validity. And then the Second and Federal Circuit said, no, as long as it's arguably within the scope of the patent, we're not even going to inquire, it's legal. Then the 11th Circuit, in this case, kind of followed that, changed its own rule. And then last year, the Third Circuit said, wait a minute, this is anti-competitive. We think these things are illegal. So a lot of the arguments the government has now for 5 or 6 years been arguing in 3 or 4 different cases, take this case, take this case. Certainly since the Obama administration, both the Justice Department and the FTC have been arguing for the court to take one of these cases. But now, after the Cater decision in the Third Circuit, you had a very stark circuit split. Right? You've seen a number of circuits move to a very deferential review, and then the Third Circuit come back and take exactly the opposite position and say these things are presumptively illegal. And I think that is kind of what drove the court to take this case. One thing I'll note about the sort of oddity of the kind of rule of reason discussion, this is a 5-3 opinion written by Justice Breyer. Alito did not participate. And it is mostly the liberals, along with Kennedy. It would not surprise me at all to learn that some of the disconnect between the it's not presumptively illegal, just use the rule of reason, and the actual details of how the rule of reason is supposed to be implemented come from an effort to get Justice Kennedy on board and his reluctance to sign on to a new per se rule or something like a new per se rule. So this may well have been some jockeying for votes in an effort to avoid a 4-4 split, which would have left the thing unresolved.
Any other questions?
So I think over the years, Congress has proposed some ways to deal with the reverse payment situation. Is there anything left for Congress to do after this case?
There's still issues, maybe not so much with the reverse payment, but with settlement of these cases. I think if Congress's intent is that these patents should be challenged, then I think they're going to continue to try and put limitations on the settlements. The other thing, and I think our amicus brief kind of argued it a little bit, is this concept of why only the first filer? Why should they get the 180 days? So everyone understands, and I think it's set out in the opinion pretty clearly, the real benefit to the generic is this 180 days of exclusivity during which no other generic will be approved for the marketplace. You still have to worry about the authorized generic, you have to worry about other first filers, but you have some bit of this exclusivity. And so the argument is, okay, the first generics settle, what's left for those who were late to the game with their abbreviated new drug application? Shouldn't there be a reward for anyone, any generic that challenges successfully the patent and either shows it's not infringed or it's invalid? And Congress has never taken that up. There have been some proposals, they've looked at it, but they've held to this first to file gets the benefit as the first to be successful. And I think that is an area that Congress may still look at because they're still going to be faced with settlements and blocking and cheaper generics not necessarily getting to the marketplace because a generic didn't want to take the risk and spend the $2 to $3 million to litigate it all the way just to have someone launch and get the 180 days.
And on the kind of flip side of that, you might imagine Congress also saying, well, to get your 180 days, you got to earn it, right? And settlement alone wouldn't necessarily buy you 180 days. Only invalidation or proof of non-infringement would get you that position. Now, there is a bill, Senator Klobuchar's got a bill that predates the Actavis decision that would have restricted reverse payments quite severely. That bill is still floating around, and I think she's still pushing it. My view, frankly, is, whether we need legislation is a function of what happens in the trial courts after this decision. It might well be that the kind of things that legislation's pushing for, you're already going to see as a result of Actavis, and if Robert's right that the settlements are going to change their character, then it may be that you don't need to act, at least with respect to reverse payments in Congress anymore.
I think we're out of time. Thank you very much, gentlemen.
Thank you.